Right, well, welcome everybody to One Chancery Lane's webinar on COVID enforcement procedures. It is exactly 1 year since the coronavirus received royal assent, and we're marking the occasion by just looking at some of the practical problems that the various restrictions on enforcement and asserting rights might have. So there's three of us speaking today. Richard Cherry is going to start off, and he's going to talk about the impact on landlord tenant in in residential cases. I am going to talk after Richard about landlord tenant in non-residential cases, and Conor is going to look at the situation with insolvency. We've all thought that we haven't got very much to say, but no doubt we're all going to end up speaking for more than the sort of 15 minutes we've allotted to ourselves, but we'll try and keep ourselves under control on time. And if you've got questions that arise out of anything that we say, please put them in the Q&A, and we'll either pick them up as we go along or certainly at the end. And one thing we're not going to be covering today, which I should mention, is the debt respite scheme, breathing space and moratorium and mental health crisis moratorium regulations, which will be coming into force on the 4th of May 2021. We're going to leave that to our colleagues Simon and Chris, who are going to be doing a webinar on the 28th of April to talk about. So if that's something which is of interest to you, you'll be able to book for that particular webinar. Before I hand over to Richard, I'd just like to say one thing, which is it's been a year of coronavirus, and we've been doing these webinars not quite for a year, but one of the things we have really appreciated is attendance by you guys coming along and listening to us. Working in our silos makes us a little bit isolated, and it's been really enjoyable and a very welcome break to be able to host these webinars and speak to you. So without any further ado, I'm going to pass over to Richard.
Thank you very much, Zach. Yes, it's lovely to, assuming we're not actually speaking into the void and people haven't just turned their computers on and walked off for a coffee, which I could understand if they do. There is a lot of ground to cover. I'm only going to try to cover one slight part of it, and that is the part of the legal framework that I hope people will be most focused on, and that's actually the enforcement. But what we've got is what I hope is now relatively familiar Practice Direction 55C, which, along with the overall arrangements for possession proceedings in England and Wales, snappily abbreviated to the overall arrangements, they changed the rules around residential possession claims. And the overall arrangements in particular sets out the slightly new ways of working that the courts have adopted. I'm going to say a little bit about that from my own perspective, but I think we're all a bit in the dark. So if there are questions or indeed helpful comments on how things have worked in people's own experience, feel free to contribute them, because it'll be very interesting. But by our very nature, we're only active in a tiny proportion of all the cases that happen, so it's good to share a bit of that knowledge. So beyond those two pieces of work, we get the primary legislation, the 2020 Coronavirus Act, and then we now have a raft of amending legislation, and the secondary legislation, Public Health Coronavirus Protection from Eviction England, number 2, and indeed there was number 1, Regulations 2021, Coronavirus Act 2020, Residential Tenancies Protection from Eviction Amendment England, Regulations 21, and the Public Health Coronavirus Protection from Eviction and Taking Control of Goods England, Regulations 2020, which is the one that I'm actually going to focus on, because that is the one that tells us more about enforcement. So we'll move on to our next slide. So the Coronavirus Act, as is often the case with the underlying legislation, doesn't actually do a vast amount of the work. It was originally enforced until September 2020. It's now going till 31st of May 21, which is also what all the amending regulations are working towards. That, as you probably know, prescribed new notice periods for the notices seeking possession against Rent Act, secure, assured tenants, and all the other sub-forms of tenancies related there, whether they're demoted, introductory, etc. It also modified the prescribed forms, in particular forms 3 and 6A, which are what old people like me like to remember as Section 8 and Section 21 notices. And it is important to use them. I've been involved in a case lately about using an older version where it was held that you didn't have to use the new version, but my goodness, you save yourself a lot of time litigation if you do, and they are available on the government website, so route not to really. It also sets out in Schedule 29 its own procedure for amendments, which is just as well because there have been lots of them. And as I noted in our jaunty little preamble, they seem to have mutated almost as fast as the virus itself. So the purpose of the 2020 regs was just to modify that Schedule 29, thank you, just to amend Schedule 29 from 28th of August 2020. Now, what, as we probably know, I hope this next slide is fairly familiar to people, the new notice periods, it's generally 6 months for 88 Act tenancies. The exceptions are set out, and they also put them on the new forms, which is quite handy. So you can check that. There's also a list on the government website of all the notice periods, which I think is up to date. But I would say look at the prescribed form, because that then gives you all the permutations. They can be quite complex if you're using more than one ground at once. They're basically 6 months, but the exception, and an important exception, the 14, 14A, 14ZA and 17 are shorter, 14 at once. These are the ASB type bad behaviour grounds, rioting, including them, at 1 or 2 weeks. But the most common ones, ground 8, 10 or 11, without ground 7A or 14, where obviously if you're going with those other ones, you can go quicker. If you've got at least 6 months rent at the service of the notice, you can serve one with a period of 4 weeks. If not, you're back to 6 months. So it's even if you're serving ground 8, sorry, section 8 notice relying on ground 8, so you've got 2 months rent or more unpaid, there is this crucial distinction between 6 months rent and not 6 months, and it may well be worth waiting or serving one without prejudice to your right to serve another, and then serving another when it gets past 6 months of rent arrears. Obviously, it will depend on your particular circumstances. And Section 21 notices 6 months. That's the thing that a lot of people aren't getting. It's a dreadful difficulty for landlords. 6 month for a Section 21 notice, and the biggest kicker of that is if, for instance, often before a client comes to you, they may have served their own Section 21 notice and either got the notice wrong, served it in the wrong form, not complied with any of the formalities, gas safety records, how to rent, etc., and you then have to tell them they've got to reserve. They will be very sad to hear that it's going to take 6 months, but that's it. That's where we are. So onto the amending regulations, the 2021 regulations. They were great. They were really simple. Back one, there we are. All they did was extend that relevant period to the 31st of May. Brilliant. We've dealt with those. Thank goodness for that. Next one. This is the enforcement bit, which is probably going to be most important and most relevant. People may already have come up against it. The number 2 regs, 2021, just as the previous regs, it's Regulation 2 and Regulation 2.3. Subject to paragraphs 2, 3 and 5, no person may attend at a dwelling house for the purpose of A, executing a writ or warrant of possession, or B, delivering a notice of eviction. The exceptions are, of course, so that in itself obviously says there are going to be no evictions until the end of May. So the exceptions are all those ASB and related grounds. And again, most commonly, I think for most of us, where an order is made wholly or partly based on arrears. So again, most commonly we're looking at ground 1 in Housing Act 85, grounds 8, 10, 11, Housing Act 88, and there are arrears of 6 months or more, and that was previously in the old regulation 2.3, that was 9 months, and it previously also disregarded any arrears that had arisen since the 23rd of March 20, so around the start of the lockdown. And the logic was clear that people who had been forced into arrears or had their arrears pushed over that boundary by the emergency would not be penalised. That's now gone, and it's 6 months. Now, at what date? The shelter website is, as ever, very good on all of this and is an excellent resource. That suggests that it's both at the time an order is made, which I think is incontestable. It must be that there would be arrears of 6 months at the date of the order, but also at the date of the warrant. And I can see that because if we're executing it where it's been made and there are arrears of 6 months or more, I understand that, but it may be importing the that subclause into the earlier one because it is where the court is satisfied, and I'm not sure where the court would be involved in the warrant itself. Obviously, if we're challenging the execution of the warrant, that's a different matter. But I think that's an open question at the moment, and there may arise some case law on it. One piece of important case law that there has been is that if an order is made on Section 21 ground, it can't be enforced, even if when it was made there was that required level of arrears. And the Trinity House case, which I've referred up there, and I've given its full name because it's quite a beautiful name, is the authority for that. It was before a High Court master. An order had been obtained, and there had been a Section 8 notice served and a Section 21 notice. There were arrears above the required level at the time of the hearing, and the order was only made on Section 21. They didn't get it made under ground 8, for instance, even though that ground was made out and the 6 months was satisfied. They went back and not unreasonably said, well, of course we should be able to execute. There were massive arrears. I think there were £70,000 of arrears in the case. But no, the decision was if the order is made on the Section 21 ground, you can't enforce it until at the moment, May the 31st, and possibly thereafter, we just don't know. So the tip, and this really is from Zach, who had a case like this, ensure that your order records the ground and the level of arrears as being over 6 months, because what are the bailiffs going to do when you go to them with your order and it's not clear? So ensure that is recorded on the face of the order if the judge will do it for you. So just to round up, where are we now? What's happening on the next slide? Well, evictions are stayed until 31st of May, but of course there are those exceptions. Those exceptions have changed. No longer 9 months, it's 6 months. There are further new versions of Forms 3 and 6A, possibly since the last one, and the old new periods for notices continue. So it's generally 6 months notice, but the 4 weeks obviously for more than 6 months. Any slight non-possession issues that I've come across, it's clear that the repairing obligation is unchanged, even if you can't get in. There is non-statutory guidance, which has been revised, which you can look at if non-statutory guidance helps any of us really. Gas safety, again, if the tenant is self-isolating, a landlord can postpone their gas safety check until it's safe to carry it out, unless there's a direct risk to the tenant or the household. But I query, where does that leave the landlord's obligation re Section 21 notice, because they haven't amended the gas safety regulations themselves. So while you won't be risking a criminal prosecution if you end up doing your check late, if you need to serve a Section 21 notice and are prevented from carrying out the most recent check before that, that may then invalidate that. So that the question is, do you feel you can get in? But the gas safe operatives do have guidance on working safely, and in theory are prepared to go in. So moving forward, got just a couple of issues on the ground. Have there been different approaches between county courts? I've noticed some. The process of the R&S hearings seems to be largely consistent in the courts that I appear in. They've all been London courts of late. Their decisions as to whether hearings will be remote or face-to-face has been less consistent, although largely all interim applications seem to be taking place remotely, although Uxbridge, for instance, have insisted on having a face-to-face CMC. What are the courts doing about COVID marking and prioritisation? Because there's quite a lot of discretion in the judge's case managing that. It's hard to say, but what you've got at the moment, when they talked about the dedicated cadre of district judges who'd all been trained in the new regime, the case management of possession claims, as far as I'm aware, is dealt with only by those judges, and they are keeping DDJs, for instance, more or less in the same courts, so that they can get some consistency. And a practical but very annoying point for me, the courts appear to be answering their phone less. So I've had a lot of solicitors putting in orders by email, complying with orders by email, filing their documents to the email address that they've been given and told to, and not getting an acknowledgement. And then they're ringing the court and they can't get through, and they are not unreasonably doing their nuts because they don't know if the court has accepted that they've complied. But the courts now generally have, as far as I've seen, they have a dedicated possession email address. Some have changed. They gave out an earlier version and they've changed, so keep checking. And they always, in my experience, put it on the order itself. So do have a look at the order and the email address that it gives, because they had changed that. That is me. I'm sorry for overrunning. I will chuck you immediately onto Mr. Bredemear.
Right, thank you very much, Richard. So Conor and I are going to speak alternately now. We're going to cover the relevant law which applies to our two areas, and then we're going to look at some of the problem and practical questions that we've encountered or that might be encountered because of these restrictions. So for my field, landlord and tenant non-residential restrictions, the most important provision is Section 82 of the Coronavirus Act, and that prevents enforcement of a right of re-entry or forfeiture under a relevant business tenancy for the non-payment of rent during the relevant period. So we need to unpack each of those expressions, and they're all defined in Section 82. So rent includes any sum a tenant is liable to pay under relevant business tenancy. So whatever the way in which the sum is described in the lease, you can't forfeit for it. And then relevant business tenancy, it is a tenancy to which Part 2 of the Landlord and Tenant Act 1954 applies. I'm going to look in a moment at what those tenancies are, but you will recall that there are some quite complicated provisions which provide for occupation by somebody other than the tenant to count for the purpose of the 54 Act. That's widened even more by B, a relevant tenancy which a tenancy to which that part of that Act would apply if any relevant occupier were the tenant. So the doors are thrown wide open for the definition of relevant business tenancy, so long as you've got a relevant occupier, which is a person other than the tenant who lawfully occupies premises. And so on Section 23, this tells us whether we've got a tenancy to which the 54 Act applies, and the essence of it is that you've got somebody who is occupying the premises for the purposes of the business they carry on, or for those and other purposes. And then it's important to bear in mind that in subsection 2, the concept of business includes any activity carried on by by a body of persons, whether corporate or unincorporate. So where you've got a company or a collection of individuals acting as an unincorporated association. They don't need to be carrying out commercial activity. Any activity will do for it to be a business tenancy and a relevant business tenancy for the purpose of the Coronavirus Act. Now, so far as the relevant period is concerned, the relevant period is the period from the day after the Act came into force, so that's from 26th of March 2020 onwards. And then the period is prescribed by regulations. It's been extended a number of occasions, essentially by 3 months at a time. The current period expires on the 31st of March 2021, but there will be new regulations coming into force on that day, which will extend the period to the 30th of June 2021. So we are with the Section 82 and its consequences for a little time to come. There are then some further provisions in the Act which deal with the types of orders that the court can make, and effectively these subsections require the High Court and the County Court, when considering making orders for possessions for forfeiture for non-payment of rent, to ensure that the date of possession expires after the relevant period. And that is both when the order is being made and if the tenant is applying for any extensions of time to an existing order. So you're not going to get possession back until this relevant period has ended if you've issued proceedings before the relevant period started. The good news for the landlord, insofar as it is good news in Section 82, is that during the relevant period, waiver by the landlord can only occur by express waiver in writing. Now, for various reasons, the waiver of right to forfeit for non-payment of rent is a lot less serious than the waiver of the right to forfeit for other obligations, but landlords at least have the confidence that the waiver of right to forfeit for the non-payment of rent has to be expressed in writing. So Section 82 is the main restriction so far as non-residential premises are concerned. The other restriction to mention relates to commercial rent arrears recovery, or CRAR. We'll be familiar that this is the process which used to be distress, the levying of distress, and it's now to be found in the Tribunals, Courts and Enforcement Act 2007. Pre-COVID, Section 77 provided that you couldn't exercise CRAR unless there was a minimum amount of rent in arrear, both at the date of serving your notice that you were going to exercise CRAR and when you came to take control of goods. That was normally 7 days under the taking control of goods regulations, but as a result of amendments made to take it for the COVID situation, and if I can have the next slide, please, Connor. You will see that it's expanded considerably. So if you were giving your notice of enforcement before the 24th of December, there must be 276 days rent in arrears, and after that 366 days rent in arrear. So it effectively really cuts out CRAR from being in consideration for the time being. And you'll see that it's during the relevant period. The relevant period is the same as we've looked at under the Coronavirus Act, Section 82. So for until at least the 30th of June. And then the final point from me on this section is that it's not legislation, it's not legally binding, but be aware of the Code of Practice for Commercial Property Relations during the COVID pandemic. It's a voluntary code, but what it recognises is that landlords and tenants may well have mutual interests in business continuity, and give some guidance about the advantages and the ways to go about negotiating new arrangements for the payment of rent whilst the pandemic persists. So that's all from me for the time being. I'm going to hand over to Connor.
Thanks, Zach. So I'm just going to talk about 4 changes that have been made in the sphere of insolvency enforcement. First up, you'll probably all be aware that there has been a change to the ability to bring winding up petitions. Creditors are prevented from petitioning on the basis of statutory demands that have been made. That was extended only yesterday to, well, it's beyond the 30th of March deadline now, to the 30th of June 2021. It seems unlikely that that's going to be the last extension of the sort of inhibition on presenting petitions. It's probably, given the fallout from from this pandemic. It's probably going to be extended until about October, is generally the sort of the feeling in the industry. Companies are also restricted from, obviously that just relates to statutory demands. Companies are also, our creditors are also generally restricted from petitioning on other grounds such as a judgment debt, unless they can show that they have, well, that they reasonably believe that the coronavirus pandemic has not had a financial effect on the debtor company, or that the facts giving rise to this situation would have arisen even if the coronavirus hadn't had an effect on the company. So that's an important distinction to bear in mind. It's not the case that you can't bring any winding up. It's just that it's much more difficult to do so, and you can't do so on the basis of a statutory demand. Turning then to termination clauses. So these are clauses in supplier contracts that very often appear and provide that in the event of an insolvency sort of situation, that either a supplier can stop supplying or can change payment terms. Those suppliers are now prohibited from relying on those clauses unless there are certain exceptions. It's important to note small suppliers are exempted from this. That's a company defined as having a turnover of less than 10.2 million in the previous 12 months, or a balance sheet of less than 5.1 million, or less than 50 employees. And to satisfy the court that you're a small company exception, you need to have two of those three conditions. Companies can also apply for permission to terminate their contract, their supply agreement, on the grounds of hardship, and that's again only yesterday been extended to the 30th of June this year. Again, it seems very possible that might be extended further. The third of the four changes I'm going to discuss is relaxed entry requirements to this new moratorium procedure. So these temporary rules, again, yesterday extended to the 30th of September this year. They've waived the requirement that a debtor company obtain a court order to get a moratorium, that a monitor assess the debtor company as the moratorium being likely to rescue that company as a going concern, and they've got rid of the requirement temporarily that the debtor company not have been subject to an insolvency process, administration, or whatever in the previous 12 months. And there are certain companies, not all, but certain companies carrying out regulated financial activities which would otherwise have been extended from the moratorium that are temporarily eligible. And then finally, wrongful trading. So as most of you will know, liquidators and administrators can seek a declaration in certain circumstances where a director has allowed a debtor company to continue trading at a point beyond a reasonable point when the director should have known that that the company was no longer sustainable. This temporary amendment, again extended yesterday to the 30th of June this year, means that the court will not take account of losses incurred during the period in which businesses were suffering from the impact of the pandemic. And certain financial services firms, again, usually those with permission under FSMA to carry out a regulated financial activity, or public-private partnerships, are excluded from the suspension. I'll come back after Zach's example with some examples of how these might apply to different companies in different sectors after Zach's example.
Okay, thanks, Conor. So what I'm going to look at next are some of the practical consequences of the restrictions that we've already looked at, and some of the issues that arise around COVID. Now, The main restriction is obviously the inability of landlords to forfeit for the non-payment of rent. And the first point really to think about is, does the landlord actually want to forfeit for the non-payment of rent anyway? If the landlord doesn't have another occupier for the premises, doesn't want to use the premises himself, does the landlord really want the premises back at all? Is the landlord better off keeping the tenancy running along? Rent is accruing, the debt is accruing, there may be some prospect of getting money at the end of the day. So unless the landlord's got a purpose for recovering possession of the property, it may well be that in the current climate in which we're in, actually, this is a restriction which doesn't affect what the landlord actually needs to be doing. Another point to bear in mind, of course, is that if the landlord does forfeit, then once the empty property period of 3 months has come to an end, potentially the landlord's going to be liable for business rates. So there's another reason to keep the tenancy running. And another possibility is that it may be that the tenant, although it's struggling to pay the rent, can benefit from some form of government support, bounce back loan, or so forth. And it may be that there are means for the tenant to at least get some money to pay the landlord something towards the rent arrears. Why might the landlord want possession though? Well, one reason may be to prevent damage to the property. The landlord may be concerned the property is empty and is looking to preserve the structural integrity of property. The landlord may have a redevelopment plan that it wants to implement, and being able to forfeit for non-payment of rent might be a convenient way of recovering possession so that the landlord can start. So that's a reason why the landlord might want possession. And then another reason why the landlord might want possession is potentially to preempt an insolvency process. So if the tenant becomes insolvent or enters a moratorium or a creditor's voluntary arrangement, the landlord may find his rights as landlord are diminished, and he may want to preempt that happening and get possession back before the insolvency process occurs. If really what the landlord is after is preventing damage to property, then the landlord might want to ask whether an injunction will do. So there's no restraint on injunctions. And so ask yourself, if you're acting for a landlord, whether or not the injunction is a satisfactory remedy. So I'm going to then look at two specific problems now. The first problem is what you do with the unoccupied property. And the second problem I'm going to look at are Section 17 notices, which of course are the notices you would serve on a guarantor of the tenant's liability to pay the rent. Now, the problem might arise in this way of the unoccupied property. We know that for there to be a relevant business tenancy, there has to be someone occupying the premises for the purpose of the business. What if you've got premises which appear to be unoccupied? The tenant's not been trading for a very long time because of lockdown, because its clientele has all disappeared. Are you able to run the argument that the business is not occupying the premises? Well, the case of Poynton points that you probably got quite a lot of difficulties in establishing that. Poynton decided that a tenant does not need to be physically present in the premises in order to occupy them for the purpose of Section 23. If he is using them in some way as an incident in the ordinary course or conduct of business life, provided they are private premises occupied for no other business occupier and are not being used for a non-business purpose. So it may be the premises are deserted as an incident in the ordinary course or conduct of business life. Now, whilst COVID is an extraordinary circumstance, an ordinary way of responding to COVID is not to be physically present in the property. And in the case of a Bakioki, a tenant was held to be occupying for the purpose of business, even though the tenant had vacated 12 days before the tenancy came to an end. So just because you don't have your tenant physically present, and perhaps even they've removed all the goods, all the furniture for protection or whatever from the unit, doesn't mean to say they're not going to be occupying for the purpose of the business. And what your solution might be, if you suspect that is the case, is not to peaceably re-enter, but potentially to bring possession proceedings for the court to determine that question. the landlord can at least get a judgment for the arrears as part of those proceedings if the court finds that he wasn't entitled to bring the possession claim. So the second problem then is under ARGAs and Section 17 notices. So we know that under the Landlord and Tenant Covenants Act 1995, former tenants are released from their liabilities under the tenant covenants, but the landlord can insist on an authorised guarantee agreement in order to make the former tenant liable for rent that the incoming tenant fails to pay. And we will also all remember that you have to serve a Section 17 notice on your new tenant if you want to exercise your rights under the ARGA. And the date in which you have to serve your Section 17 notice is within the period of 6 months, beginning with the date when the charge becomes due. So the first question then that we need to think about is, if you enter into some sort of rental concession with the tenant, is that potentially going to release the surety? Now, this is all part of a case rule, sometimes known as rule in Home and Brunskill, and that provides that any material variation to the terms of the principal contract, so that's the contract between the creditor and the principal person liable, can have the effect of discharging the surety. And that rule is applied quite strictly. So unless the court can determine without having to look into the matter, unless the court can say it's self-evident that the alteration is unsubstantial or can't otherwise be beneficial to the surety, unless the court doesn't need to inquire into the matter, then the effect is that the surety is released from their obligation. Now, you might think that extending time for someone to make a payment of rent is something which can't be to the disadvantage of the surety. Well, that's not where the cases are currently stacked up to say. So generally speaking, the extension of time to the debtor is regarded as something which often will release the surety. And the reason for that is that the surety in principle has the right to insist on the creditor enforcing his rights against the principal debtor. The surety also has, in theory, the right to pay the debt off himself and then look to the debtor for repayment of the sum that the surety is paid. And the thinking is that if the landlord has given the tenant extra time to make the payment, then that undermines those rights of the surety. Another way where it's sometimes looked at is that if you extend time to make a payment of an obligation, that may, in the long run, increase the risk of default and increase the risk that the surety in the long run is going to be called on. So for those reasons, an agreement, and it has to be a binding agreement by which the tenant is given time to pay rent, can have the effect, it's thought, of releasing the surety's obligation. Now, in the context of COVID, most of the arrangements which might be made between landlord and tenant, it will be argued, are not contractually binding. And we all remember rule of Focus and Beer that there's no consideration if you agree to accept a late payment being paid. However, there is authority to the contrary. There's a Court of Appeal case, MWB Business Exchange Centres and Rock Advertising, and it's not the only case, but it indicates that that practical advantages can amount to consideration. So in the MWB Business Exchange Centres case, effectively, the occupier discovered that it couldn't make payments, and it orally agreed that the payments would be deferred towards later on in the term. And then the Court of Appeal, Lady Justice Arden identified as amongst the practical advantages for the landlord, one of the practical advantages of avoiding a void. Now, it seems to me that that is exactly the same sort of argument that could be run to say that there's consideration provided in the sort of rental concessions that we're seeing being granted by landlords at present. Now, MWB Business Exchange Centres went to the House of Lords sorry, the Supreme Court found against, so allowed the appeal on a different point in relation to whether or not a non-written agreement clause was effective or not. But Lord Sumption said that the question about consideration, the Court of Appeals analysis, was a difficult one. And he reflected on the fact that there were contending Court of Appeal authorities about the idea about whether a practical advantage could be consideration, and ultimately said that the reality is that any decision on this point is likely to involve a re-examination of the decision in Folkes and Beer. It's probably right for re-examination, but if it is to be overruled or its effects substantially modified, it should be before an enlarged panel of the court, and in a case where the decision would be more than obiter dictum. So potentially, the rents and concessions that we're seeing in COVID potentially are going to give rise to circumstances where this point might have to come before the Supreme Court. And it's worth noting that Lady Arden, of course, who was in the Court of Appeal in MWB Business Exchange, is now in the Supreme Court. So potentially it's a bit of a watch this space. Now, this may all be irrelevant to you if you're a landlord and you've got a well-drafted ARGA, which expressly provides for the landlord to be able to give time to the tenant to make payments. But not all ARGAs have those provisions. Very often they might just refer to neglect or forbearance, which is not the same thing as an express agreement by which time is given to the tenant to make payments. So you need to read the terms of your ARGA very carefully if you're a landlord thinking about serving Section 17 notice, thinking about the terms on which you're going to enter into rental concession, whether you need the surety's agreement to it. And then the final point about Section 17 notice is, when does Section 17 notice need to be served? Well, it's 6 months from when the charge becomes due. And Scottish and Newcastle and Raggers tells us that that's when the tenant is contractually bound to make the payment, when the landlord can sue for the money. And so potentially the Section 17 notice may not need to be served until the date that that concession requires the tenant to make the payment. But obviously the safest course, if you're a landlord thinking about Section 17 notices, is to serve them as soon as or within 6 months of the rent falling due as per the terms of the lease. So watch this space. I expect in the next 12 months there will be cases on this. But for now, that's all I can offer on this potential problem. I'm going to pass over to Connor.
Thanks, Zach. So I've got three very unimaginative scenarios for this insolvency enforcement area. The first is a debtor travel company. Obviously, pretty much every travel company has been severely hit. A lot of them have gone out of business. So how do these temporary changes to insolvency enforcement affect your average travel company? So can it enter a moratorium? Yes. I mean, it probably could anyway, but it certainly benefits from the relaxed entry requirements, no need to get the permission of the court and so on. Can creditors petition to wind it up? So not, well, simply no, not until after the 30th of June in any case. What's the position with its supplier obligations? A travel company would be protected under these sort of the suspension of reliance on supply contracts or termination clauses. Of course, small suppliers are still exempted. A lot of travel companies, small suppliers will be small suppliers, and also a lot of them will be facing hardship. And finally, what's the position on wrongful trading of directors? Again, this is clearly a case where directors would be protected because, of course, their losses, the losses of almost all travel firms will be almost entirely attributable to the coronavirus pandemic. Our second example is a very different. The other end of the economy in the pandemic is bicycle shops. Everyone's taken up cycling, something to do, a way to get around that's safer. but companies like this can still take advantage of the relaxed entry requirements into a moratorium. They still benefit from the protection against winding up petitions on the grounds of statutory demands. But I have to say, if there's if one sought to wind up a company or to petition in relation to a company that had done very well out of the pandemic, so bicycle companies perhaps. Not obviously, you're not going to be petitioning to wind up Amazon, but another company that's done very well. The debtor company probably wouldn't be protected because, of course, it's very unlikely that the pandemic's had anything to do with its financial troubles. It's really going to be something else if a company like this is in trouble during the pandemic. Supplier obligations still protected, although again, small suppliers aren't, and those facing hardship can escape the duty to continue to supply. And finally, wrongful trading. Well, again, probably the losses or the financial difficulties of a bicycle company during the pandemic probably wouldn't be attributable to the pandemic, so probably wouldn't have that protection from wrongful trading liabilities as a director. And then finally, financial service companies. Obviously, this covers everything from banks to investor funds to insurance firms and financial advisors. So it really depends on the specific nature of the business. But as soon as you see a debtor company that is engaged in the financial services area, you need to sort of check the detailed rules within, I think it's Schedule 4 of the CIJA. But generally, these can be, they're not ordinarily eligible for moratorium protection, but they can be depending on the company and the business of the financial services company. In terms of supplier obligations, they're likely excluded from this temporary protection. And again, wrongful trading, likely excluded, but it will depend on the exact nature of the business. So just if you see a debtor company with providing financial services, just be aware that you need to check the very exhaustive detail within the schedule of CIJA 2020. So that's a very brief run through of three sort of very basic example scenarios for insolvency enforcement. In terms of questions and answers, I think we've got 4 questions. So
I think Richard's been
Richard would like to answer that. Yeah.
Richard, do you want to answer the ones that you've been looking at and then tell Conor and I about the ones that are relevant to our stuff?
I will do just that. Well, tell you what, I'll do it in the other order. Zach, the question on commercial rent arrears recovery, I think is yours. Can CRAR be used prior to the 30th of June 2021 for arrears of rent which have been outstanding for 6 years? Do you want me to go to the other one? Do you want to do that right now?
Yeah, no. I'll take that. So the effect of the regulations that we talked about are to relate to the period of rent arrears you've got, not how overdue they are. So if you're starting enforcement now, you need to have 366 days worth of rent arrears, so more than a year's worth of rent in arrear. If your rent is 6 years in arrear, if you've got 6 years rent unpaid, then CRAR's available. But of course, if you were only to have, say, 6 months, which was 6 years overdue, then that wouldn't be 366 days. The other point to bear in mind about the question is, of course, you've got a limitation period on rent, which is 6 years. So be aware of that.
And I think this is a common one. Has the moratorium on winding up petitions been extended to the 30th of June 2021?
Yes, this was just yesterday. I'm just getting the legislation now, and I think I can hopefully publish it in this chat. If I type an answer, does that go to everyone?
See, there's an answer being typed.
Hopefully everyone can see that. That's just a link to the extension regulations. Only came out yesterday, it comes into force tomorrow. So yeah, it was quite, one really has to keep an eye on updates from this government, because they sort of, not in any way a sort of political criticism. It's just the nature of the pandemic, of course. It is unprecedented territory, and a lot of this is sort of, inevitably last minute legislation. I think, as I say, most of these deadlines have been extended to the 30th of June or the 30th of September. It's in section 2 and 3 of these latest extension regulations. I have to say it's almost certain that the winding up situation is going to be extended again until October. I don't know if it's going to be a cliff edge or how the government's going to do it, but I doubt this is the last update we're going to have on these insolvency enforcement amendments. I'll just see if we've got any more. Is that everyone?
Can anybody just, I can see the link that Connor put up. Can anybody who is a participant rather than one of us three hosts just confirm that you guys can all see it? That would be very helpful. I've got a question that I mistakenly said I wanted to answer live, which is, I know, sorry, those ones.
There's another question from Natalie there as well.
Yeah, no, I've seen that.
There's one question. In order to enforce, it seems you have to file an N244 following the making of an order for possession. I wasn't aware that you need to file an N244 in an ordinary case. I thought you simply meant where you don't require permission to enforce. I was under the impression that you simply filed an N235. There may be solicitors here who know more about this than I do, because it's not part of the procedure that I've actually handled myself. But that was my sort of second-hand impression. There's a very annoying question because I don't know the answer. So thank you for the person who asked it, but it's an important question. Are possession orders being granted for licensees who remain after their permission has expired? Yes, they are. Such licensees are trespassers, but not obviously those who entered as trespassers. They originally entered with by license and then became trespassers at the expiry of their permission. So they're not going to be the persons unknown trespassers. They are covered under the public health regs. I'm just trying to look at the appropriate bit now under regulation 2. The possession can be enforced against trespassers pursuant to claim to which Rule 55.6 applies, but not if it doesn't. And so I feel it feels very odd that, let's say there's a licensee who has had their license terminated by notice to quit, and maybe in more than 6 months of arrears, hasn't gone. But I'm not aware that there is an exception in the 2021 regs, the public health protection from eviction number 2 regs. If anybody is better informed on this, having done one than me, that would be brilliant, and they can tell the class, because I haven't come across it. So done the moratorium on winding up petitions. We've done the CRAR question. I don't see any other open questions.
The question.
Oh, got one. Sorry.
Lee White's question, Richard, which is, what's the position on mixed-use premises and enforcement where a possession order has been made on the grounds of forfeiture based on the terms of a commercial lease, with the demise of which includes residential dwellings? Richard will correct me if I'm wrong on this, but it seems to me that the starting point is that if you've got business premises, your 54 Act, your relevant business tenancy. So you've done well to get your order of possession on the grounds of forfeiture, if it was on the grounds of rent arrears. But once you have got your order of possession in terms of enforcing it, you're still going to have a person who's occupying for the purposes of the dwelling. And so you're still under the Protection of Eviction Act. You still need to employ bailiffs or High Court enforcement officers to actually enforce the order. And you're going to need to bring yourself within one of the exceptions to the no enforcement in order to execute your order. Would you agree with that, Richard?
Yes, and I don't think you can.
Well, unless you've got sort of 6 months rent in arrears or something like that.
The difficulty is that the 6 months rent arrears.
You wouldn't have got forfeiture on that basis.
You require an order made. You need an order made either on ground 1 in Schedule 2 to the Housing Act 85, ground 8, 10 or 11 in Schedule 2 to Housing Act 88, or the case 1 of the Schedule 15 to the Rent Act. So that's just dealing with secure, assured and Rent Act tenancies. Now there are also, obviously, as we mentioned, there are exceptions for other breaches like ASB, etc. But I think that is possibly falling through one of the gaps, because you won't have if the occupation is just based as part of 54 Act tenancy, you won't have gone under Part 55 anyway. So I think you may be stymied. Thank you to people who kindly confirmed that they can see the link. That's very helpful.
Richard, there's a question from Sharon.
Yeah.
Envisaging a company where the company's been dissolved and the director's still residing in the property. No, I think.
What you said?
No, but it seems to me that's just straight. You're going to need to wait till you've got your 6 months rent in arrears, and then an ordinary claim for possession. If the company's been dissolved, the Crown's going to be the defendant, because the lease will be bona vacantia. So your defendants will be the Crown and the director who's residing there.
I'd cross over. I don't think the director. I don't see that the director would be a defendant, because
But he's in occupation, so you'd name him, wouldn't you? I mean, I would.
Yeah, you could. You name him as an
as a
occupier.
defendant.
Your defendant is the company. The company's been dissolved. I don't know if this is the old company law issue. I always ask other people about company law, the director themselves. What are they? Have they become a trespasser?
Well, the lease is. I mean, assuming the lease is still continuing. I mean, the lease may or may not be continuing.
Well, you terminate the lease by your notice to quit, because it's a contractual tenancy. So under whichever provisions are required by your contract.
Yeah, because either it's a periodic tenancy, you can terminate a notice to quit, or you've got a well-drafted fixed-term agreement and there's provision to terminate on insolvency.
Yes,
so terminate the contractual arrangement.
Termination on insolvency anyway. So if it's then terminated, yeah, he becomes a trespasser. But
he's a trespasser. Yeah, he can pay damage.
Somebody has very kindly helped that if the licensee is an excluded occupier, then they're not protected from the COVID regulations. But I don't see where they can be evicted. That's my difficulty.
Well, I'm not sure they will be an excluded occupier.
No, sorry. This is just in relation to a different question. The a licensee. Sorry, that's me being unclear because I'm jumping between the two. That's another one I'm going to have to look at. It is, you know, it's terra incognita. Terra definitely with an OR. Trying to see if there are other questions that we can have with.
I think that's it.
I think that's everything.
I think it is.
All right. Well, thank you everyone very much for coming. It's very much appreciated that we've got such a able audience and such great questions. So thanks for coming.